In this chapter, we examine the structure and functions of the federal judiciary. We also consider the types of cases that proceed through the judicial system and the system's role in establishing public policy. Finally, we analyze the appointment and confirmation process to the federal judicial branch. Article 3 of the Constitution establishes the U.S. Supreme Court and all inferior courts created by Congress. The federal judiciary was meant to interpret federal laws, issue rulings on disputes where no law existed, punish violators of the law, and compensate victims if possible. The framework of the federal judiciary didn't exist before the 1789 Judiciary Act, which created the national network of courts under the auspices of the Supreme Court. The court system is meant to be impartial, largely apolitical, and wholly separate from the other branches of government. Much of the court's legitimacy comes from the perception that it's above political interests. However, the court has often been the means through which interest groups and individuals seek to effect political and social reforms that couldn't get passed through Congress or the executive branch. This fact, coupled with the inherently political process of judicial appointment, has sometimes put the court into the middle of bitterly fought partisan issues. The United States Judiciary Act of 1789 was adopted in the first session of the First United States Congress, establishing the U.S. federal judiciary. The act created 13 judicial districts within the states that had ratified the Constitution and established a circuit court and district court in each judicial district. The three types of cases heard by the federal court system are those in which the U.S. government is a party, cases regarding the federal constitution, federal law, or treaty, civil suits between citizens of different states that involve a certain monetary amount. These cases are heard by the district courts, the appellate courts, and the Supreme Court. The federal judiciary features a three-tiered system consisting of district courts, appellate courts, and the U.S. Supreme Court. The bulk of the work is done by the system of district courts. There's at least one district court in each state and 94 in total. Most federal cases with trials in the district court begin with trials in the district courts. Federal district judges are appointed for life by the president and confirmed by the Senate. District judges can also appoint magistrate judges who, by hearing and deciding minor cases, help reduce the caseload of the district court. Court decisions that are appealed or taken to a higher court for further review are considered by the Federal Court of Appeals. There are 11 judicial circuits throughout the United States and its territories. The 12th and largest is located in Washington, D.C. Circuit courts normally operate as a panel of 3 judges. The Supreme Court is the ultimate appellate authority in the U.S. Only a small fraction of the cases that have proceeded through the district and appellate courts are considered by the Supreme Court, although those that it does decide tend to have the biggest impact on society. Most federal cases are decided in district courts. Some are then appealed to appellate courts. A tiny fraction of these make it to the Supreme Court, which has the final say over the outcome. Circuits serve different geographic regions, which vary dramatically in size. The First Circuit includes only the northeastern portion of the country. The Ninth, by contrast, includes the entire West, along with Alaska and Hawaii. District court cases that are appealed proceed to the U.S. Appeals Court, which can affirm the district court's decision, reverse it, or refuse to take the case, letting the district court's decision stand. The high costs in money and time often dissuade litigants from continuing the appeals process. Most appeals that reach the Supreme Court come with the writ of certiorari, a formal petition seeking the court's review. These appeals originate from either federal appeals or a state Supreme Court. The court can also grant or deny each writ. A minimum of 4 justices must show interest in the case for it to proceed. That is why it is called the Rule of 4. The appeal must raise an important question of federal or constitutional law with broad public significance in order for it to be considered. While the number of potential cases that reach the Supreme Court has grown considerably since the 1970s, The court's discretion in choosing which cases to hear has also expanded, and as a result, the majority of appeals are rejected for a wide variety of reasons. This is a case in which the Supreme Court is resolving a dispute between states. Just as an example, North and South Carolina have long been at battle over a disagreement about rights to the water in the Catawba River. And I want you to think about this on your own for a little bit. In your view, what right, if any, does South Carolina have to water from a river that originates in North Carolina? That is an example of a decision that the Supreme Court must make a decision on. Upon deciding to accept a case, each party prepares briefs presenting arguments, precedents, which are decisions that have been made in the past already on a case of a similar nature, and background for the court to consider. During oral arguments, each party has 30 minutes for their argument, during which the justices can ask questions, make comments, or consult among themselves. Then the court meets in private conference, and each justice states his or her conclusions on the cases that they have heard. The Chief Justice delegates the writing of the majority court opinion. If the Chief is in the minority, then the most senior justice performs this function. The majority opinion is how the Supreme Court announces and explains its decisions. The justice assigned to write the opinion of the court must secure the approval of at least 4 other judges. In order to get a consensus, opinions are negotiated and compromises are often made with other justices. Often, a justice will write a dissenting opinion to provide a basis for future courts to reconsider the issue. A concurring opinion is an opinion that's written by a justice who agrees with the decision, but for different legal reasons. Upon the court's decision, the case is often returned to the appellate or state Supreme Court to instruct justices how to decide similar cases in the future. We'll learn how these justices are appointed later in this chapter. Current members of the Supreme Court are, beginning in the top row at the left, Elena Kagan, Samuel Alito, Sonia Sotomayor, and Neil Gorsuch. In the bottom row, Ruth Bader Ginsburg, Anthony Kennedy, Chief Justice John Roberts in the middle, Clarence Thomas, and Stephen Breyer. You should be able to answer this question without hesitation. What is the highest U.S. Court of Appeals? The U.S. Supreme Court has appellate jurisdiction over state Supreme Courts as well as over lower federal courts. The Supreme Court oversees the nation's entire judicial system. The resolution of disputes, playing referee that is the primary function of judges within the federal judicial system and society at large. Judges determine the legal remedies to violations of statutes and agreements at the local, state, and federal levels. The U.S. judicial system is an adversarial system. The disputing parties make arguments and present evidence before an impartial judge or jury. Many other countries use an inquisitorial system in which the judges play a more active role in the proceedings. In the American system, the plaintiff initiates a lawsuit by filing a complaint, and the defendant is the person or institution against whom the complaint is made. Citizens selected to serve on a jury listen to a trial and issue a final verdict. Criminal cases often involve the violation of statutes designed to protect the public, such as assault or theft. A civil case concerns a violation of the legal rights or obligations of one individual toward another. In these cases, the plaintiff is another individual or a group. Civil cases are determined on the preponderance of the evidence, and the penalties are often monetary in nature. Cases brought by individuals acting on behalf of themselves and others commonly affected are known as class action lawsuits. In these cases, the rulings affect not only the individual, but the group being presented as well. There were some glitches with the Apple iPhone 4 that was released in 2010. In an effort to ward off a class action lawsuit, Steve Jobs held a news conference at which he promised to provide free cases to customers who purchased the new mobile phone. Standing is a legal requirement for going to court. It means that to take a case to court, one has to have experienced actual harm. It isn't enough to be appalled by a situation. One has to be the recipient of the harm that is done. Judges may also determine that a case isn't yet ready to be heard. This principle is called the rightness doctrine, and it holds that courts will accept cases only when the actual harm has taken place. Occasionally, the costs of going to trial and the uncertainty of the outcome are deemed to be too great, and the parties will settle out of court. The terms of the settlement in these cases don't have to be disclosed to either the court or the public. An agreement between the prosecutor and the defendant in a criminal case through which the parties agree to a specific crime and punishment is known as a plea bargain. Plea bargains resolve an overwhelming majority of criminal cases today, although each agreement still has to be approved by a judge. Each year, the district court process several hundred criminal and civil cases per judge. Caseloads have been increasing at an alarming rate. District court cases have tripled, and appeals cases have increased to more than 13 times their number from 1960 to 1995. Associated court costs and delays in processing court judgments have accompanied this trend. The rise in the number of cases nationwide has many observers worried that the extent to which litigation has become a part of our society. Elected officials and judges have noted with dismay that the number of frivolous lawsuits draining resources from the court system have increased. Studies have suggested that while America may be more litigious than ever before, it's inconclusive as to whether or not the country is more so than other industrialized democracies. The sheer volume of existing case law requires lawyers and judges to conduct a tremendous amount of research in preparation for trial. The majority of cases in the U.S. legal system are heard by state courts. State courts interpret and apply their own state constitutions and law. Each U.S. state maintains a judiciary of its own, divided between trial courts and one or more levels of appellate courts. In addition, most states have a number of other courts that have limited jurisdiction on a particular issue, such as special family courts, probate court that handles wills and estates, traffic court, juvenile court, municipal court that handles breaches of city ordinances. When state court decisions raise a federal question, federal courts are able to review them. Federal courts may also consider convictions at the state level if civil liberties are at issue. In cases presenting a conflict with federal law, the Supreme Court is the only federal court that may review state court decisions. A plaintiff is a term used in the U.S. for the party who initiates a lawsuit before a court. Two other words sometimes used for plaintiff are claimant and complainant. Judges create common law when no legislation exists and develop rules that dictate how to resolve certain types of disputes. Cases involving contracts, property, and personal injuries are based on common law. In contrast, public law deals with the governmental statutes. In these cases, judges determine the constitutionality and the correct meaning of the statutes in question. They can also step in if there's been a bureaucratic failure in implementing the statutes. The power to interpret the Constitution, which is called judicial review, was established as a precedent by Chief Justice John Marshall early in the Republic's history. In essence, this theory allows the Supreme Court to declare laws of Congress, laws of the state, and actions of the president unconstitutional and invalid. This power established the judiciary as an equal voice in the determination of public policy. Political scientists have identified three models of decision-making: legal, attitudinal, and strategic. Judges make decisions by trying to deduce the correct interpretation of the law and relevant portion of the Constitution. The courts place a great deal of weight on the actions of earlier courts. The rule of precedent, also referred to as stare decisis, implies that judges are expected to abide by previous decisions of their own courts and by rulings of superior courts. Most often, however, judges are granted wide latitude in applying the rule. Differences in constitutional interpretation can produce greatly different outcomes on the same legal question. There are two main schools of thought: judicial activism and judicial restraint. Judicial activism assumes the belief that the courts are free to decide whether to abide by past court decisions, which do allow them to consider possible outcomes, public opinion, and their own preferences before issuing a ruling. Judicial restraint, however, limits the exercise of the court's own power by overturning past decisions only when they're clearly unconstitutional. The attitudinal model holds that judges use nothing more than personal policy preferences to make decisions. Judges picked by Republican presidents tend to be judicial conservatives, and judges picked by Democratic presidents are more likely to be liberals. Since the 1940s, only 10% of judicial appointments have gone to candidates from the opposition party. Most appointees actively support their parties. There also seems to be a strong relationship between judges' decisions and their ideologies. One study indicated that roughly 80% of the time, judges rule on civil liberties cases in ways that are consistent with their ideological preferences. Further, many of the Supreme Court's most important opinions seem to be tilted toward the ideological viewpoints of the individual justices. Accusations of judges imposing personal preference regularly come from both sides of the aisle. While the outcome of every case can't be predicted solely from judges' ideologies, the attitudinal model paints an unflattering picture of the judiciary. In the strategic model of judicial decision-making, judges consider not only their own policy preferences, but the actions of the other branches of government as well. They must also take into account the manner in which their decisions are enacted and whether the decisions are likely to be upheld. In this model, judges are political players within the political system. The Solicitor General has the responsibility of presenting the executive branch's views in cases to which the U.S. government is a party. The Supreme Court accepts more than 75% of the cases in which the Solicitor General's office is the petitioning party. The Solicitor General enjoys an extremely high success rate when it gets involved with cases, either directly as prosecution or directly through the use of amicus curiae briefs. Amicus curiae, or friend of the court briefs, may be filed by individuals and groups that are interested but not a party to a particular case. These briefs contain the information or arguments believed to be relevant and useful to the court. Finally, there's substantial evidence to suggest that the judges are highly influenced by public opinion. An example is the court's assent to President Franklin Roosevelt's executive order to intern Japanese Americans during World War II, an act of unquestionably that was not constitutional and that no doubt reflected public sentiment at the time. Fred Korematsu, shown here in 1983, was the subject of one of the most important wartime cases ever decided by the Supreme Court. In a case that bore Korematsu's name, the Supreme Court upheld the internment of Japanese Americans during World War II. Federal judges are appointed by the President and with the advice and consent of the Senate. The length of judicial appointments strongly influences the President's selection. Presidents want to ensure that those who share the same views and values will occupy the seats of the courts for years to come. Most presidents since World War II have had the opportunity to nominate more than 100 bench seats. The average age of judicial nominees is somewhere in their 50s, and they tend to be wealthy. More recently, the courts have become more representative of the nation as a whole in terms of race and gender. Currently, there are 6 men and 3 women on the Supreme Court, and 2 of the justices, Sonia Sotomayor and Clarence Thomas, belong to minorities. Most often, judges are nominated because of their political ideology and judicial philosophy when they match the president's. Despite increasingly partisan Congresses, most district court appointees are confirmed. By contrast, nominees to the appellate court have had a more difficult time in securing Senate confirmation. Senate courtesy, the president's custom of submitting the names of prospective judges for approval to the senators from the states in which the appointees are to work, remains very important and often makes confirmation easier at the district level. This custom doesn't apply to either the appellate or the Supreme Court. Among the more controversial appointments made by President Obama to the appellate courts was Goodwin Liu, a constitutional law professor at the University of California at Berkeley, who espoused traditionally liberal views on a variety of political issues. Here he's seen greeting Senator Dianne Feinstein just before testifying before the Senate Judiciary Committee. After a protracted battle, Republicans in the Senate derailed his appointment. The White House staff and the Justice Department advised the president in compiling lists of potential Supreme Court nominees. While presidents are likely to consult with important members of the Senate prior to nomination, partisanship over confirmation of Supreme Court nominees has increased in the years. A nominee also faces scrutiny from professional legal organizations, from investigatory agencies, from the public, and from the media. Groups, particularly legal-based interest groups outside the government, also try to influence potential judicial nominations. Before consideration by the entire Senate, all judicial nominations are referred to the Senate Judiciary Committee for a hearing, during which senators may question the nominee, his or her previous rulings, or judicial ideology. Most often, nominees are deliberately ambiguous in their responses. Historically, the Supreme Court nominees are less likely to be confirmed by the Senate than appellate or district court nominees. Among Supreme Court confirmation hearings, Clarence Thomas's in 1991 was one of the most politically charged in recent memory. Because the Supreme Court justices serve for a life or until retirement, everyone hopes that the next one appointed will share their views. Can you answer this question about the nomination and confirmation process for a Supreme Court justice? Article 2 of the Constitution states that the President shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. Now, as we close out, is the judicial branch an effective check on Congress and the President? How has the role of the federal judiciary affected everyday life? And what role should the Supreme Court play in determining public policy? Those are questions that I challenge you to stop and think about as you close out this chapter.